types of evidence do we have here? It's testimony, documentary, and real, my dear.
Testimony is when a witness goes on the stand, swears to tell the truth by raising their hand, talking deadly as anything, written or printed, but nowadays it includes stuff like emails and texts. Who would have thought it? Finally real are those things we can see, taste, or feel, and maybe listen to carefully and hear a victim squeal. For the jury to know it, it must be admissible, and that's the judge's job with the jury out if possible.
All types of evidence do we have here? It's testimony, documentary, and real, my dear.
Hello there, mighty seekers of truth. I'm Neil, here to discuss what is evidence. So grab your CSI bag, a pint of logic, and warm up those vocal cords. And let's dive into the wonderful world of what counts and what doesn't as evidence. All right, picture this. You walk into court, someone says, "I've got the evidence." What do they really mean? A piece of paper? A fingerprint? A witness who can't stop yawning or who speaks so quickly nobody can understand him? How do we know it's good evidence? Well, today we'll explore exactly that. The nature of evidence, the rules around it and why it matters, with some laughs and hopefully no illegal evidence. Evidence is the information presented to a fact finder, judge or jury to support or refute a fact in issue. For this video, we're going to look at the traditional types of evidence, namely testimonial evidence, documentary evidence, and real evidence. In future videos, we are going to look at how one gets evidence into court, admissibility, and the criteria we use. Not everything automatically becomes evidence in court. It must satisfy certain tests, relevance and materiality. The evidence must relate to a fact in dispute, not that someone once liked cats. Reliability. The court must trust or at least assess the trustworthiness of what's presented. Burden and standard. Who must bring the evidence and how strong must it be? So let's start with the different kinds of evidence. There are three traditional types of evidence: testimonial, documentary, and real. Testimonial evidence is all to do with a witness giving evidence, in other words, testifying. Witnesses must be competent, which means they must be able to testify. Essentially, this means they must be intelligible, able to be understood by the average person. Witnesses must be compellable. In other words, they can be forced to testify even if they don't want to. As a rule, testimony must be sworn. This means that by taking the oath, religious, or the affirmation, non-religious, the witness promises to tell the truth and acknowledges that if they are caught fibbing, known as perjury, they face jail time. Witnesses under the age of 14 and people with intellectual disabilities do not need to take the oath or affirmation. But the trial judge must be satisfied that they understand the importance of telling the truth and that they can get themselves into serious trouble if they do not tell the truth. Finally, here's a bit of a curveball. Although people often think of testimony as oral or spoken evidence only, in certain proceedings it is possible to have testimony on affidavit, which is a formal written statement made on oath. In other words, although it looks like a document, smells and tastes like a document, an affidavit is classed as a species of testimonial evidence. Confused? You and me both, kiddo. But seriously, an affidavit is the written, sworn version of what a witness would say on the stand, allowing the court to consider it as evidence, even without live testimony. Documentary evidence is a tricky one, mainly because it covers so many things. When it was first created as a category way back when, it essentially meant written evidence and then later printed evidence. Now we have email, texts, and various other forms of cyber correspondence, and the original formulation of documentary evidence is being stretched at the seams. so it is perhaps more useful to describe it as evidence that contains a record of some kind. Modern Irish law regards a wide range of items as documentary evidence, including written documents, maps, photos, audio and video recordings, and computer records, which all serve as a record of some kind. The law is technology neutral, accepting both traditional and electronic documents, and there are rules about how they must be presented to court to ensure their admissibility. Examples of documentary evidence include written materials, which means anything with writing or printing on it, such as letters, contracts and reports, visual records, including photographs, films, negatives, videos, maps, plans, graphs and drawings, audio records, which are things like sound recordings on tapes or other media, digital and computer records. This is a category that is getting bigger by the day as technology is growing faster and faster. Computer printouts, electronic transmissions, and other computer-generated information all come under that broad category, which itself is a category of documentary evidence. Other records, birth certificates and medical records are also considered documentary evidence. As I said, it's a category that's bursting at the seams. And finally, real evidence. Real evidence is any material, physical object that is presented to the court for direct inspection, examination, or testing. It is evidence that exists in a tangible form and can be perceived by the senses, seen, touched, felt, or sometimes heard. Its key features are as follows. It is physical, for example, a weapon, clothing, damaged property, fingerprints, blood samples, drugs, tools, and so on. It speaks for itself. The judge or jury can examine it directly without the need to rely only on someone's description of it. It must be properly identified. The witness presenting it must confirm what it is, and that it is in the same condition as when it was seized or found. It must be authenticated. There must be a clear chain of custody showing how it was handled from discovery to court. It is different from documentary evidence. Real evidence is the object itself, not a record describing it. So real evidence is the lifeblood of TV dramas. Those scientist-type cops who come to court and give evidence about fingerprints, DNA, blood spatter, tire tracks, left-handed or right-handed, and so on. So, although the definition says that real evidence speaks for itself, in reality it is usually introduced by a witness who will tell the jury all about it and why it is relevant to the case. What is different is that the jury get to see it, feel it, and perhaps hear it or taste it or smell it, and this use of the senses makes that evidence more understandable and hopefully tallies with the description by the witness who is authenticating it. Irish courts have repeatedly confirmed the admissibility of real evidence where it is relevant to the issues in dispute, and it has been properly preserved and authenticated. So, there you have it. The three traditional types of evidence whose boundaries are constantly being pushed by the advances in technology. I'm Neil, and this has been The Law is My Oyster.
What types of evidence do we have here? It's testimony, documentary, and real, my dear.
Testimony is when the witness goes on the stand, swears to tell the truth by raising their hand. That I never read is anything written or printed, but nowadays it includes stuff like emails and texts. Who would have thought it? Finally real of those things we can see, taste or feel, and maybe listen to carefully and hear a victim squeal. For the jury to know it, it must be admissible, and that's the judge's job with the jury out if possible.
What types of evidence do we have here? It's testimony, documentary,